Hello and welcome back. I'm Roger Royce, host of the 10,000 Startups podcast, where each week we bring to you another episode focusing on an area of the law specific to startup companies. This is for you, the founders, the advisors, anybody who works in the startup community, the legal issues that you really need to know about. This week, we're going to talk with Stephen Malm. He's counsel in our labor employment practice group in San Francisco at Haynes and Boone LLP, where he leads the immigration practice group. Steve has vast experience representing small, mid-sized, and even large companies in immigration and compliance matters. And, here in Silicon Valley, where I practice, far more than half of the companies that I see come into this valley tend to be from other countries. And they all have immigration issues, every one of them, because they want to bring people over. They want to know if the founders can work there. They want to, that we can't get away from it at all. So I end up contacting Steve quite a bit. So Steve, thanks for being here today. I know this is going to be really interesting to our audience.
Absolutely, Roger. Yeah, thank you. Thank you for having me on.
So let me kind of start off with the big question, and we'll drill down into the details in a minute. But the one question I get from everybody is the founder says, hey, I'm here on this tourist visa or whatever, and I've been here a long time, but I want to start a company. Am I allowed to do that? What's the answer to that question?
Yeah. So, as with any question, there's a bit of nuance to that response. But generally, there is guidance that says that someone that is here, either if they're of a nationality that doesn't require a visa, such as most European countries and Korea, Japan, then they might be here on a 90-day visa waiver program type of stay, which doesn't require them to actually have a visa, but they only get 90 days. Or they could be here as a visitor, whether it's a business visitor, which is a B1, or they could have a standard visitor visa that's both business related or visitor for pleasure. And during those stays, there is guidance that states there are certain activities that are permissible that someone can undertake if they are an entrepreneur or starting a business. Generally, the limits of those categories are it's phrased as meetings or undertaking steps to establish the business or court investment. It can be a fine line in terms of what crosses over that line. And it's clear that someone in the U.S. as a visitor, whether it's as a visa waiver or as a B1 visitor, may not receive compensation or in exchange for rendering services. That crosses over into what immigration deems employment. And if activities are starting to cross over that line, and it's not merely engaging in meetings or meeting with investors, courting investment, or undertaking certain activities to get the business started, that person needs to find a viable work authorization or some visa category that enables them to work to make things more comfortable, not just during that stay, but when the next time they're traveling to the U.S. Because when people are coming to the U.S. and they're engaging in meetings and they may be doing things that are entirely permissible as a business visitor. But if there's a higher frequency of visiting, which naturally there often is, if really the focus is on expanding or founding the business in the U.S., that tends to draw scrutiny and makes for uncomfortable interactions with the border officials, known as Customs and Border Protection at the airport.
Before we get into that, let me pause on that for a second.
Yep.
Because what you said, I think, is really significant because a typical startup company client, the founder is going to form a company here, a corporation usually. They're going to be a shareholder, which I think is okay. They're going to be a director. They're not getting paid for that. But then they're almost always also going to be an officer. And of course, that makes them a statutory employee here in California.
Mm-hmm.
And so I think what I'm hearing you say is that's that's probably okay as long as they don't take any compensation. Is that right?
That's right. So what I will do for someone, if there's an abroad company in existence and it's opening or expanding operations to the US or opening a subsidiary in the US, is make clear in a letter. So this is common for someone traveling for that type of a purpose, to carry a letter from the abroad company that outlines the activities that they will be engaging in when they're in the US, and makes clear in that letter that they will receive no compensation from a US source during their stay. So that is a clear prohibition, and it's an area where people can slip up if they haven't been thinking about it.
Yeah. So let's go to the next question I have then is like, well, what if I do want to get paid by my company? Can I have, you mentioned a B1 visa. I know there's something called an H1B. And then they say, is there a way that the company can sponsor me and employ me and bring me over and get me a work permit? Is that possible?
Yeah, so we refer to the various work authorization visas as the alphabet soup of visa categories. And as an immigration lawyer, we're running through that A through Z list constantly to see what might be a good fit for someone who's say an entrepreneur founding a company. And often, so there are quite a few that you can eliminate, but the main ones that you'll see are an L1 visa. If you're founding a new office in the US and you're either an executive or you're a manager, or you could even be a specialized knowledge employee coming to open the US office. If the US business has not been operating for at least a year, then there's an L1 visa that's filed as a quote unquote new office L1. And the key to that is that the person needs to have been an employee for the business abroad for at least a year in an executive, managerial, or specialized knowledge capacity. Can become a little tricky if someone new is appointed and you know they haven't worked for the company abroad for a year, and you want to bring them over as an executive or a manager. Can also be tricky if that person was not actually on the payroll of the foreign company, which can be the case for high level folks where there's not actually a paper trail showing they were an employee. They may have received other sorts of you know payouts, but it's not payroll. And that's challenging for an L1. But generally, that's one of the first options you're going to look at is opening a new office as an L1 visa, where you can transfer someone from abroad who has worked for the abroad entity for at least a year. This is something that people really need to think about, and the other visa categories that may be available when they structure the company. It makes things a lot easier if there are immigration considerations in a case, if there's a clear ownership relation that is easy to chart for immigration between the abroad entity and the US entity. And there needs to be a quote unquote qualifying relationship, meaning it's either a parent subsidiary or there's a qualifying affiliate relationship. And so qualifying affiliate means you basically have the same ownership. And then you can transfer that person to the US. Now, same ownership is itself something that needs to be strategized carefully, because it needs to be the same owners in the same percentage.
So parent sub would work out okay, right?
Parent sub is the best way to structure it. And so if a primary concern, and as you mentioned, this is often the case, so many companies are founded by foreign nationals. So immigration can be a paramount concern. Setting it up as a parent subsidiary is generally going to be the easiest way to do it.
Yeah. Now let's suppose, and that's oftentimes the scenario, that, you know, we have an existing company that's done well overseas and they want to launch in the US market and bring some of their team over. So that sounds like the most likely approach in that scenario. What if it's a fairly new company here, overseas, anywhere, brand new? So we don't have that 1 year of history that would get us the L1 visa. What are the options then?
Yeah, so if you don't have the 1 year abroad, then you start to look at some other options. One that I turn to a lot is the O1 Extraordinary Ability Visa. And extraordinary ability, it certainly, connotes a very high standard, and it is, extraordinary is a pretty weighted word that you think, okay, this standard is going to be challenging to meet. But there are criteria for the O that you can assess whether there's a viable O1 case or not. And the term extraordinary, that sounds quite daunting, but in reality, these are quite attainable. So for an O1 extraordinary ability visa, that's something you would look at, say, for a founder type entrepreneur that has had success in business in the past or in their field, and they haven't worked for the company abroad, or it's a new company. To get the O1 visa, USCIS publishes criteria on this, and you basically need to meet the threshold of 3 of 8 criteria. And I'll just note from experience, the ones that generally we argue to get those 3, to get the O1 visa for founder entrepreneurial types, are that they've made original contributions in their field, original contributions of major significance in the field. Usually you can get letters, either an independent expert and testimonial letters from references of that person that can state that, yes, they've made original contributions. 2, another criteria of the 3 that we need to meet is playing a leading or critical role for an organization with a distinguished reputation. Just anecdotally, that's one we can tend to establish. But generally, this is someone that would have experience already working. If somebody's absolutely new and hasn't developed a track record of business or in their field, challenging visa category to get. But for people that are a little more experienced in their field and have made those original contributions and have worked in leading roles or maybe founded other businesses, that's a criteria that is very attainable as well. And then that third one, that third criteria is the one where we need to strain a little bit sometimes to get it. But I oftentimes published material in major media about the person or in a trade publication can be satisfied. And frankly, this is not an application that is fixed at the time I consult with someone. You're free to sort of help manufacture a stronger case through, hey, maybe a media outlet would want to publish an article about what this person's doing. And, generally the person is very excited about, their new business and the type of work they're doing, and such an outlet can be found. And so then we've got our third criteria. We often will throw in a fourth of high salary remuneration at some point in their career. But 3 is really that threshold we need to meet. And it's all about creating a narrative, and having strong reference letters is another key part of this. But that tends to be the category I would look at first if someone doesn't meet the eligibility.
That sounds like a tough one, and it sounds very fact-based. What about do you rely on how about the B visa? That's the one I seem to hear most about.
Yeah, so the B visa, again, it's for visitors. It's for business visitors. And it can be great, for initial kind of startup activities. But the concern is when you're using the B visitor visa with greater frequency and your stays are becoming prolonged in the US, you start to get questioned at the border, and it can become uncomfortable because it's not a quote unquote work visa. Doesn't allow you to be paid by the US entity. So really what we're solving for when we move over from a B to an O or an L is you don't have to deal with this hassle at the airport anymore.
Right.
And you don't have to structure your activities in a way to make sure you're not crossing over into quote unquote employment. So the O1 is one that, if you're high enough up in the company, or if you've got enough of a kind of a track record of success, it's often one we can get approved for someone. And it can be, in terms of the petition itself, the operation doesn't even need to really be up and running yet. You can actually have someone serve as your agent to file such a petition, rather than have the company be the one to file. So there's some creative ways to approach an O1 to make it work. But So that's one I wanted to flag, but then Roger, since on that topic of what other categories, since on that topic of what other categories do we look at, there's also something called an E2 investor visa that we'll use.
Yeah, I was going to ask you about that.
Yeah.
People are very interested in that one.
Yeah, so the E2 investor visa, definitely a great option if you're from a country that has an E investor treaty. So that's really the threshold inquiry about on the E investor visa. Of note, China does not have an investor visa in E2, so there can be quite a few people, nor does India. So there are a couple, the two biggest countries in the world by population don't have this option available to them, but many other nationalities do. And the E2 is very similar to the L1, except you don't need that 1 year of employment abroad. It's all about, are you investing substantial amount of money into a U.S. business? It can be directly as an individual or in a company abroad investing the money in the U.S. business. And like the L, someone who qualifies for the E based on their treaty nationality can come to the U.S. as an executive or a manager, or in the E2 context, rather than specialized knowledge, they call it essential skill worker. But it becomes a medium for transferring large numbers of employees potentially that hold that same nationality of the company. So if a large percentage of the employees are nationals of that country, then that suddenly becomes a great tool for creating the ability to bring that knowledge from abroad and transfer employees.
Do we have that treaty relationship with India? Because I certainly see a lot of companies.
Yeah. So it would be a total game changer if that ever happens. But as of yet, there is no E2 investor treaty with India or China. Both countries, obviously, they're foreign nationals, a large number involved in tech, but they don't have the option of availing of the E2. From India, I think you'll often see the L1 being used where they've just gone ahead and made sure they have the 1 year of employment abroad before opening the U.S. office.
Before we leave that, now the E2, did you say that requires an investment into the U.S. company?
That's correct, yes.
And you have to hire a certain number of employees as well?
So you would want to show a viable business model, and it would contemplate that you would be hiring employees in the U.S., but there are mom and pop type E2s where it's literally opening a small restaurant and it's not a huge number that you're employing. The key requirement there is that it can't be marginal just for the investor to earn a living for themselves. It should have a broader impact. And as with any case, it's sort of like I mentioned with the L1, the narrative of the case is very important. Presumably, for the clients, Roger, that, in the VC or say a tech entrepreneur space, there's sort of a bigger vision than that type of a mom and pop, but the fundamental standard there is that it can't be marginal just for the investor to earn a living. So what you want to do with an E2 investor application, and as you would do as well with an L1, is present a business plan. So as an attorney, an immigration attorney, you maintain a cozy relationship with your business plan writers. So you have a good referral network of people that can write business plans that will address these types of concerns and projections for who you would be hiring, how many you would be hiring.
Okay, gotcha. Well, good to know.
Yeah.
I noticed that you also do a lot of work with something called an H-1B visa. Does that have any application here in the startup world?
It can. It's limited in its application due to the cap or the quota on H-1Bs. It's a very high in demand visa. And in the last few years, there have been record numbers of applications. So just for a little more background, there are 85,000 H-1B visas allotted per year. And there's always excess demand for those 85,000. And to deal with that, they run a lottery. And historically, the chances of winning that lottery were around 30 to 40%, with slightly higher odds if you had an advanced degree. But there have just been a flood of these names submitted into the lottery because of a different process, which has made it much easier. So people are more speculatively submitting names into that lottery hat, which have made the percentages drop significantly. And to the point where it's not really, it's something you could attempt during the lottery season, which is March and April of each year. But the odds of getting that H-1B visa are lower than they've ever been. We're talking 10 to 20% range. And this lottery only happens once a year for a start date that is in October that same year. And so the limited numbers affect that as a viable option. But I would note that as far as startups and entrepreneurs, it is potentially an option for someone that is a founder. You need to be careful about showing there's a true employer-employee relationship. So that gets into how things are structured again and consulting with an immigration lawyer. If it is envisioned that H-1B, the H-1B would be a visa that they would pursue. It's important that there's there's control over that founder somehow built into the way the company is organized. So through a board of directors or
I'm kind of curious as to why that wouldn't be your go-to right away. I mean, you mentioned all the other ones first. Is there a reason that's less desirable?
Yeah. So it's certainly worth putting your name in the H-1B visa lottery hat. I think, it's very low effort to do that. But it's just the odds are not something you can rely on. You're looking at 10 to 20% chances of getting the H-1B. And a lot of people are looking for, I want to get this thing up and running now. And so I'll make a note on the timeline practically so you can see how this works out. So if someone were to come to me today and they said, "Oh, I want to explore an H-1B visa to operate my company," I would have to tell them that, okay, there are no H-1B visas and numbers available right now. We can submit your name into a lottery in March of next year. And if you're lucky enough to get that H-1B visa number, your start date could not be until October of 2024.
Gotcha. Okay, I'm gonna add one last thing I want to cover here, but we've gone through a ton of information. But I've been hearing forever about this thing called startup visa. Is that a thing? Is there such a thing? Are we going to get that?
Right.
Where if you're a startup company, you automatically, are allowed to come here and work and help our economy. What is that about?
Yeah, so we don't have what is exactly called a startup visa. And to an extent, used loosely, some of these visa categories we've been talking about are referred to as startup visas, depending on how they're prepared. But the closest thing we have now to a quote unquote startup visa is something called the International Entrepreneur Parole status, which is an application that can be made. There are quite strict requirements about that. And it's similar in ways you could say to an E2 investor visa with a minimum investment amount. And there are requirements about who the investment is actually coming from. But it is something that entrepreneurs should have on their radar. I would say that it has been little utilized since it was initially unveiled because of processing times that were unrealistic. But processing times are shortening for that international entrepreneur parole visa. I wouldn't even call it a visa. It's a status that they confer for 30 months to get your business up and running. And if you meet certain benchmarks, it's renewable. But it is something people should have on their radar. And it's frankly still, they're ironing out the kinks on that category. But it's the closest thing we have to a quote unquote startup visa. But I should note, though, that parole is sort of this quasi status in immigration versus a visa, which is a much more solid footing to be on. So there's a distinction to be made between what a visa is and parole, and this gets quite technical. But a parole at least would permit the ability to enter the U.S. for 30 months initially, and then renew to run a business, to get a business up and running. But there are some quite complicated requirements associated with that. And in terms of ironing out the kinks with how long it takes for them to actually approve a case, that is still a work in progress, but it's getting better and is something people should have on their radar.
Okay, great. All right, well, we'll add that to the toolkit.
Yeah.
Well, I want to thank you, Steve. We could talk all day about this. It's complex yet interesting.
Yeah.
This is Roger Royce. I'm a partner with Haynes Boone. I'm talking with Stephen Malm. He is with Haynes Boone in San Francisco. He's an immigration lawyer. I forgot to mention, Stephen is also certified by the State Bar of California as an immigration and nationality law specialist by the State Bar of California Board of Legal Specialization. We've been talking about immigration issues for startups. So Steve, if people want to get a hold of you or learn more, how do they do that?
Yeah, so I would welcome anyone to send me an email directly at stephen.malm@haynesboone.com or to call me on my direct line 949-202-3077. That's 949-202-3077. And I welcome any sort of an inquiry, frankly. Always happy to discuss any sort of immigration issue and see if there's some way I could be of assistance. Yep.
All right. Thanks very much.
Thanks a lot, Roger. Appreciate it.